Good afternoon, and may it please the court. My name is Andrew Coulomb. I'm here on behalf of the state of Tennessee. I'd like to reserve 3 minutes for rebuttal, if I may.
3?
Yes.
All right, sir.
Thank you. This court should reverse the circuit court and remand this matter back to the juvenile court for a delinquency adjudication for 2 reasons. First, the juvenile court erred in finding that double jeopardy prevented the state from filing a verified delinquency petition after the first petition, which was unverified, was dismissed. Second, the circuit court erred in ruling that the juvenile court's jeopardy attaching ruling from the dismissal of the first petition had to be challenged and prevented any sort of double jeopardy challenge later. That had to be challenged after the dismissal of the first, had to be appealed after the dismissal of the first petition, and that the double jeopardy issue could not be raised again after the second petition was dismissed. As to the first issue, the law is clear that when a charging instrument has been found to be a nullity, that under those circumstances, and then is dismissed accordingly, that there is double jeopardy is not offended. The prohibition against double jeopardy is not offended by basically then going back and filing a valid charging instrument. Usually this is in the case of criminal prosecutions. So in that case, and the law is clear on this, there's been the invalid instruments dismissed. That does not preclude the state from filing a valid charging instrument, which is what a delinquency petition is. And there's good reason for that. Double jeopardy, our Supreme Court and the United States Supreme Court have said very clearly protects 3 situations. One is when a defendant or a child has been found to be guilty or delinquent in the child's case, cannot be tried again. Or when the child has been found to be non-delinquent, then cannot be tried again. Or when there's multiple punishments for a single offense. None of those are the case here. When the first petition was dismissed, the child was not found to be delinquent. He was not found to be not delinquent. There were certainly no punishments that were handed out at that hearing. So double jeopardy did not apply under its most basic principles.
Let me ask you a question. And I understand the argument you're making, but what about the fact that the court specifically in its order stated that jeopardy did attach?
Well, jeopardy attaches. The jeopardy is sort of the initials, the threshold question in a double jeopardy issue. Jeopardy, you determine whether jeopardy attaches, and then depending on what happens afterwards, you determine whether a second proceeding was validly dismissed. So the judge did say that jeopardy attached, and in the normal circumstances, yes, that's true. When the first witness is sworn in, then jeopardy attaches. But that doesn't mean that double jeopardy prevents anything afterwards, and it certainly, and any double jeopardy ruling at that point was really not, it was premature, it was unripe. Double jeopardy comes into play when the defendant or the child has been twice put into jeopardy. And at that point when that ruling came down, the child had not been twice put in jeopardy. There was only once, theoretically or allegedly, would have been once. So the judge certainly made the ruling, but if the state had come in at that point and said, let's appeal that ruling, what the state would be saying is, well, the court said jeopardy attached. Okay. The court did not say, though it intimated, but certainly did not say, I am absolutely dismissing a second petition. If the second petition were to be filed, I would dismiss it. It was intimating things wouldn't go well, to be sure, but did not actually say that. And so the state would have to come in and say, okay, the jeopardy ruling saying that the jeopardy attached and should continue to be attached for a double jeopardy purposes was error. And I suppose we were asking the court to give an advisory opinion that in case the juvenile court should decide to dismiss a second petition on double jeopardy grounds, then you should advise that the juvenile court judge don't do that. But that is the essence of a unripe issue. In that
it's the essence of what?
Of an unripe issue.
Well, let's assume it is unripe, and let's assume that the trial court was at error in saying that jeopardy attached, but yet made the ruling, dismissed the case, made the ruling that jeopardy attached, can you at that point do nothing and then just wait to bring another charging instrument? Or would you have to file an appeal of that ruling?
No, because the appeal at that point would be futile.
Why
Because
would it be futile?
because-
You would have the circuit court looking at whether the juvenile court judge was correct in saying that jeopardy attached. And clearly, the trial court, the circuit court judge should say, no, jeopardy never attached because you had a faulty charging instrument. But in this case, unlike the cases you cited, there's not a case where when that original charge was dismissed, there's also an order that said that jeopardy attached, which is what you have in this case.
That's true. That's true. But the ruling unto itself did not prevent a second petition. In any double jeopardy case where any kind of double jeopardy claim has been raised, the threshold question is, did jeopardy attach in the first instance? If it's not, then there's nothing to talk about at all. But even if you say it does, then you look at see what happens afterwards to determine whether the prohibition against double jeopardy is triggered. Attachment of jeopardy doesn't do that by itself. That just says we're in the double jeopardy realm. What you have to go to what happens afterwards to say, no, you can't do this again. And here, all the judge said was jeopardy attached. And for us, there would be no remedy essentially for the state at this point, which is also what a ripeness doctrine would go to, is to say, well, what's the remedy for the state? The remedy to say, well, the jeopardy didn't attach. Even if jeopardy did attach, the law is clear in all those cases in all those places. Jeopardy clearly attached originally. That there was a charging instrument. The jury was sworn, so jeopardy attached. But then afterwards, it was found that the charging instrument was a nullity, was void, and so at that point, everything became void. And so that did not prevent the state from going forward and said, okay, let's get a valid charging instrument in here and let's do this right.
Does the fact that the original charging instrument was void or was a nullity, does this language by the court saying that jeopardy attached, is that superfluous language?
Absolutely, it is superfluous. It was completely unnecessary, the ruling. All the ruling had to be is that the child came forward at the hearing and said, ooh, the petition is unsworn and it has to be sworn by statute. This is a requirement. In which point all the court had to say, needed to say was, you're right. This is not sworn. This is not a valid petition. This whole matter has to be dismissed. That was all that needed to be done. It was superfluous language to go forward and say after that, well, jeopardy attached when the first witness was sworn. Whether that's true or not is frankly without merit, because then you go into the next part of the analysis is even if there had been a sworn witness at this point, in a criminal context, even if the jury were sworn, nonetheless did what happened afterwards, a motion to dismiss because of a faulty judgment or faulty charging instrument, wipe out everything afterwards. And that's what happened here. So it was superfluous language. It was not necessary. So certainly there's no collateral estoppel issue because it has to be a necessary ruling. And if the state had tried to appeal at this point, it would have been considered unripe. The circuit court, and this court would come out and say it's too soon to do this. To have double jeopardy. Double jeopardy is a second prosecution or a second proceeding is initiated. There's been a motion to dismiss. And that motion to dismiss is either granted or denied. Now we have a full and ripe double jeopardy issue. Was that ruling correct? We didn't have that until the second petition was dismissed here, and that is what the state did appeal that to the circuit court and now to this court.
So that language, what you're saying is that there was nothing really to appeal, that this language standing on its own was not ripe to appeal.
That is correct.
The charging instrument was a nullity. It was dismissed. The state agreed with that. There's nothing left to appeal.
That's correct. If the state had disagreed with the dismissal, then that could have been, that the state could have at that point said, we disagree, this should have been dismissed, and that was an appealable, something that could have been appealed. But the state didn't. The state looked at it, and it was clearly unaware until the hearing that this petition hadn't been sworn, hadn't been verified.
Couldn't you agree that the charge should be dismissed. But because the trial court, the juvenile court in this instance, is in the written order saying that jeopardy attaches, not double jeopardy, but that jeopardy attaches, you think that's incorrect. Why would that not have been right for the circuit court to make a determination about whether that part of the order was error or not?
Because at that point, the issue, a double jeopardy ruling of any sort,
Well,
even
I'm not
initial.
even getting to double jeopardy.
Okay,
I'm
initial
just
jeopardy.
getting to the issue of jeopardy attaching.
Because there would have, at that point, to say jeopardy attached would have, there was nothing for really the state to gain from that at that point. There was not a ruling that they can't file a second petition. There wasn't a ruling saying you're all done. Now, there was certainly intimations that if you file a second petition, this might not go well for you. But that was sort of the point. We hadn't gotten there yet. And to say there was a jeopardy attached ruling, I mean, we can say, well, it might have initially, but once we found that the charging instrument was void, that all goes away. The whole thing goes away. That only becomes ripe, where something's to be gained by either party, really, on appeal, is when the second proceeding's been found
Well, if you had
to be
appealed
dismissed.
it and gone to the circuit judge would have determined that jeopardy didn't attach. So there was something to be gained by filing an appeal.
Or the
Yet
circuit court.
The circuit court overruling that determination by the juvenile court judge that jeopardy attached. And then you wouldn't have faced the res judicata issue when you refiled and went to circuit.
Or the circuit court would have found this is not ripe yet. There is no jeopardy issue that can't at play here. There is a dismissal, and the dismissal both parties have found to be correct. The question is the jeopardy attaching ruling only is relevant as it comes to a double jeopardy issue, and the double jeopardy issue is not yet ripe. If there is a second charging instrument has been filed, then it becomes ripe. But until that point, a jeopardy attaching ruling is really without any import. It's not relevant to the dismissal. And the dismissal is something the state agreed with. So it's not like the state was saying, we want to reinstate the initial one. The state agreed the dismissal was proper. It was simply saying.
Would that have essentially been asking for an advisory opinion of some sort?
That's exactly the state's position, is that this would be an advisory position, advisory opinion, to say, please tell the juvenile court that if we should file sometime in the future a second petition, that's going to be okay. But that's a future and contingent event. And a future and contingent event is the heart of what the ripeness doctrine is. This was simply not justiciable.
The circuit judge could have just ruled that the juvenile court judge, you're in error in making a determination that jeopardy attached, and just stop there. That's all the circuit judge had to do.
I suppose the circuit court could have done that, or the circuit court perhaps could have said, this is not ripe. I'm not going to decide this issue.
I don't really understand the ripeness, because you've got a ruling by the juvenile court judge that you say is an error. Why is that not right to have that considered by the circuit judge on appeal?
Because the jeopardy attaching ruling has no import unto itself. There's nothing for the state to be gained yet or to be lost yet. Only to be say is that if we get to a second charging instrument, and if there's a motion to dismiss, then we can talk about the jeopardy attaching and what relevance that has, if any, to the double jeopardy issue. I mean, it's true that when the first witness was sworn, that jeopardy attached there. But then the question is.
Well, I don't know if it's a judge trial. I don't know that swearing a witness alone makes jeopardy attach.
It does.
I don't think the cases say that, but go right ahead.
Okay. I could be mistaken about that. But if it's a jury trial, it's when the jurors are sworn.
We're talking about a jury trial now. We're talking about a judge trial.
In a judge trial, it's become when the first witness is sworn. And if I'm mistaken about that, I apologize to the court.
Okay.
That's my understanding. So in circumstances, you could say that. And if we had an adjudicatory hearing, well, I see my time's almost up. Well, can I finish the sentence?
Yeah, go ahead.
Thank you. If we'd gone to a full adjudication and the child had been found to be a delinquent or not delinquent, then there probably would have been an issue there. But that hadn't happened. No evidence was actually presented. This was not a single question was answered by there. There was not, double jeopardy is designed to prevent a second adjudication on the merits. There was not a second adjudication on the merits here, and there was no double jeopardy issue.
Thank you. You have your rebuttal.
Thank you.
We'll hear from the appellee.
Good afternoon. I'm Tim Fowler. I'm the attorney for the appellee in this case. There's quite a bit of the issues that I was going to address that have been addressed through these questions. But I would begin with this. After the motion to dismiss, at no point did the court give any indication that the state had the option of refiling a verified petition. As a matter of fact, the state had specifically asked if they had the option in the transcripts on pages 23, 24, and the court had denied it. Every indication was from the court was this was a final ruling. Obviously, the state disagreed. Their remedy was an appeal. Under TCA 37-1-159, juvenile appeals, it's clear they had 10 days to file. Instead, within that 10-day period, they refiled a petition. The court had clearly said they didn't have the option of refiling a petition.
Does it say that in the order? It doesn't say that in the order.
It does not say that in the order. Yes, Your Honor, that's correct. It dismissed the case and noted that jeopardy attached. In the transcripts, the state had asked if they had the option to refile.
Well, can we look beyond the order? Can we look beyond what it says in the order?
I think with the order, you've got a final dismissal. Without an appeal of the final order, and I had noted in my response to the state's brief, in State versus Moore, the court ruled that when a judgment becomes final, the court lost its jurisdiction to amend the judgment. The court ruled on this case. Now, regardless if there was merit to the state's argument that the court had made an erroneous ruling, they should have appealed it.
Let me ask you, counsel, when you bring a prosecution and the charging instrument itself is defective, the cases seem to indicate that anything that happens in connection with that prosecution is a nullity. So if that's true, isn't any order that the juvenile court judge entered a nullity?
Assuming it's a nullity is based on the analysis of comparing this to a criminal indictment. The state's argument is that it's ridiculous to see that a juvenile petition and a criminal indictment are not synonymous. They're the same thing. And it's my contention that they did not make any argument to show how an indictment and a juvenile petition are synonymous. They go into extensive case law that talks about indictments being dismissed and being able to be refiled. You've got rules of criminal procedure as opposed to rules of juvenile practice and procedure. We're in the Court of Appeals, a civil court. A juvenile petition comes to this court. It doesn't go to the Court of Criminal Appeals. So the assumption that all charging instruments, if they're found defective and jeopardy doesn't attach as a nullity, there is no juvenile case law on point that says that. And their argument should have been made in an appeal to the circuit court. As a matter of fact, the cases that were listed, there were no cases that were directly on point to this case. There was one case, State versus Martindale, where a defective indictment, it was addressed after the jury had been sworn and the case was dismissed. The notable difference in that case was that the judge had specifically noted the state had the option to refile. The judge in this case did not indicate the state had the option to refile. My client essentially was denied due process by not having a verified petition. Basically, there was no court officer, magistrate, or judge who verified that there's probable cause to make this charge. That is never possible with an indictment. The existence of an indictment indicates this went before the grand jury, probable cause was found, and it was sent on. That's not the case here. My client had a petition that was never verified for a year and roughly 3 months. The court made its ruling. If the state disagreed, they should have filed a timely appeal.
Let's assume you didn't make the argument at the beginning of the trial that the charging instrument was defective and it went through a trial and your client was convicted, found guilty, and then later you determined that that charging instrument was not verified. Wouldn't your argument then be that that conviction was a nullity because the charging instrument was defective?
I would believe if, as the defense attorney, if I had not addressed that in court, that I've waived that issue.
You waived the issue of a defective charging instrument?
I've waived the issue. And I believe the state waived the issue by not appealing this. If the remedy is to simply refile, this is a very dangerous precedent. They could ignore whatever the juvenile court says and refile a petition. And they did it within a few days. But what if it was 3 months? What if it was 6 months down the road? Due to the nature of the crime, they could charge whenever they wanted and bring it back and create the double jeopardy issue. It wasn't ripe for the double jeopardy issue until they refiled a petition. But if the court had dismissed the case, who's to say that they couldn't create this situation based on a finding on the merits and change the nature of the charges? It's like they had an appeal, they did not take it. Refiling it reset their clock on the appeal. So the fact that they filed a timely appeal on the second charge means nothing. It shouldn't have been filed. The court had not given them leave to refile. That's all I have if there's no more questions.
Thank you. You have 3 minutes.
Thank you. In terms of whether the double jeopardy rights are coextensive or greater for children than they are for adults facing criminal charges, we know, what we do know is that constitutional protections for juveniles are lesser than what the adults face in full criminal trials. That the full panoply of constitutional protections do not apply to juveniles. Our Supreme Court said that in State v. Jones in 2006. The U.S. Supreme Court has also said that in multiple opinions, including McIver v. Pennsylvania in 1971. So in order for the child's argument to hold water, he would have to say, well, yes, that's true. A double jeopardy rights would not protect an adult with a second prosecution and a second trial. But the double jeopardy rights are now are greater and expanded for a child so that it would protect the child where it would not protect the adult. And that doesn't hold water with the case law we have, because all the case law that we have says the only reason why double jeopardy applies at all to children is because how similar they are to adults. But nonetheless, constitutional protections for adults are greater than they are for the children. So we have that, and we do have the order, which does not say, the order simply says jeopardy attached. The order does not say the state is prevented from bringing a second petition.
Counsel, isn't that implicit? If the trial court says, in connection with the original prosecution, that I've dismissed it and now jeopardy attaches,
It's
that means you can't refile the case.
It's certainly intimating things would not go well if the state were to do a second one. However, that had not yet come to pass. There wasn't a ruling. Nowhere in the transcript does it say this is with prejudice. Nowhere in the order does it say it was prejudice. And we didn't find out for sure that's what was happening until the juvenile court came back after the second petition and said no, that not only did it attach, but that double jeopardy now prevents you from doing this. Now we have the full ruling, not just the attachment, but also the full ruling saying double jeopardy prevents you. We didn't have that before, and we didn't have an order saying this was dismissed with prejudice, which would have essentially encompassed the entire double jeopardy issue. So because of that, it was proper for the state to come back to the second petition, to go to the judge and say, we say that double jeopardy doesn't apply here, and for the judge to say, no, I disagree. I say double jeopardy does apply, and if you had any trouble with at least part of my ruling from before, you should have done it before. It was unripe before, it's ripe now, and the state was right and correct to wait to file the second petition and then get the full ruling, get the full issue, so it could be properly reviewed on appeal.
Thank you.
Thank you.
All right, thank you. You may call the next case.